Good afternoon, everyone. My name is John Dallier. I am a petitions attorney in the Office of the Deputy Commissioner for Trademark Examination Policy, and I'm the host of today's webinar, which is Preparing an Effective Letter of Protest. I work, as I said, in the Deputy Commissioner's office, and I handle petitions and letters of protest, as do all of my coworkers and colleagues here in petitions in this office. We recognize that in light of the TMA, which I'll discuss in a minute, that there have been some changes in the letter of protest procedures, and we want to make you aware of them if you're not already aware of them, and also give some guidance on how you can use them to prepare a letter of protest that has a good chance of being considered. So let's start off with a couple of reminders here. The session is being recorded. These slides that you're seeing today will be emailed to you if they haven't been sent already. Captioning is available if you select the Post tab. And certainly if you have any questions related to this webinar while it's going on or later, please send questions to the email address tmwebinar@uspto.gov. There is no chat function for you to post a question that way. You must send them by tmwebinar@uspto.gov. At the end, we'll go to those questions and I'll answer them on the spot, if I can. Lastly, if you're having any technical issues, go ahead and email virtualevents@uspto.gov, assuming your technical issue allows you to still email. Okay, so let's get started. We're going to go over 6 topics today. These are the 6. We're going to review the Trademark Modernization Act as it applies to letters of protest. We're going to go over filings, evidence, the LOP form itself, some considerations you need to make about when you're filing your LOP, and then some additional information that is important for you to consider when filing an LOP. So, first, Overview and Trademark Modernization Act. The LOP process allows a third party to come in and file information that they think the office should know about a particular application without compromising the examining attorney's objectivity when they examine the application. The examination process is an ex parte process. It's between the office and the applicant. Third parties are not involved in the discussion between an applicant and an examining attorney. But this letter of protest process allows a third party to give the office information that could be helpful to the examining attorney. So it only applies to pending applications, and attorneys in my office where I work, in the Deputy Commissioner's office, we review the letter of protest that a protester would submit and try to determine if the evidence that's submitted in the letter of protest should be forwarded to the examining attorney for them to review. We call that considering an LOP. So if an LOP is considered, we will send some or all of the evidence to the record, notify the examining attorney, and he or she will look at that evidence and determine whether or not they need to act on it. If we do not consider the LOP, nothing related to it will be in the record at all. You will know you filed it. My office will know that you filed it, but there'll be nothing in the record referencing that you filed an LOP that was not considered. If you file your LOP, we prefer, but don't require, but we prefer that an LOP is filed before the application is published. And if you do that, the evidence, the relevant evidence, will be sent to the examining attorney, and he or she will make that determination about whether or not to issue the refusal. If you file your letter of protest after publication, the evidence standard is a little bit higher. You'll have to establish a prima facie case for the refusal that you think, or the requirement that you think the examining attorney should issue in an office action. If you establish the prima facie case, we will send the evidence to the record, notify the examining attorney that they are directed to issue the office action. So that's for letters of protest filed after publication. A little bit higher standard with the evidence there. So if your letter of protest, no matter when it is filed, is not considered, that determination is not reviewable. It's not petitionable. It used to be, and it no longer is. So if your letter of protest is not considered, you have no appeal rights, but you can file another letter of protest with additional evidence, or with evidence that complies with the rules that we'll go over in a little bit, as long as the application we're not 30 days beyond publication, or the opposition period has not ended. The LOP form is located as form number 10, and I'll show you that in a little bit. It is located on the petition forms page of the USPTO website. So as far as for the Modernization Act, it was passed at the end of last year, and it codified the procedures for filing and reviewing letters of protest. Those procedures were not codified before. They are now, and we follow the rules that are laid out in 37 CFR, or follow the statute requirements that are laid out in 37 CFR 2.149. So an important date to note is that as of December 27th this year, we will have 2 months to notify or review a letter of protest and notify the protester of the review from the date that it was filed. So yesterday, I was working on letters of protest that were filed on September 30th. So we are almost there, and we do expect to be responding to letters of protest filed. We do expect to be responding to them and be in compliance with the requirements. So we look forward to being timely. As far as for the procedures that we follow when we examine a letter of protest, if you would like to look at those are in the TMEP in section 1715. So if there are any questions on that section, again, you can refer to the TM webinar at uspto.gov email and send in your questions. So let's move on to the next discussion topic, filings. When you file your letter of protest, it must be timely, and you must file it using our T system, and you must pay the filing fee. Prior to the TMA, there was no filing fee for a letter of protest. There is now, so it is $50, and it must be paid. If your letter of protest has an objection in it that requires evidence, then you must also submit an index itemizing that evidence. This is a requirement under the 37 CFR 2.149. That is a change from previous procedures. You must include the protester's email address in the form, and if you are protesting several applications, you must file a letter of protest in each of those applications. Filing timeframes. We prefer that you file your letter of protest as soon as the application is filed, but preferably before the trademark publishes for opposition. If you are filing it pre-publication, that time frame is anytime after the application is filed until the day before the mark publishes for opposition. A post-publication letter of protest has to be filed between the day of publication and the close of the 30-day opposition period. If you file your letter of protest before publication, your evidence must be relevant and support the objection that you are raising in your letter of protest. It's a relevance standard. If your letter of protest is filed after publication, your evidence has to establish, as I said before, has to establish a prima facie case for the refusal or the requirement. And that evidence shows that it would that failing for the office to refuse registration or issue a requirement under the Act would likely result in a registration violating the Trademark Act or our rules of practice. So that's a little bit higher bar than filing an LOP, the evidence standard for an LOP before publication. So LOPs filed after publication, those are generally considered untimely and usually will not be considered. Some of the most common and appropriate reasons for filing a letter of protest is that there is a likelihood of confusion with a registered mark or a prior pending application. Perhaps there's a descriptiveness issue, such as or genericness issue, such that a mark should be refused or a disclaimer should be required. Maybe your registered mark is being used in an identification of goods, and that's inappropriate in that a trademark is being used possibly in a generic sense. So to fight genericide, you can use the letter of protest process. You may believe that the applied for mark that you're protesting is a widely used or a commonplace message. You would submit evidence showing why you believe that. Another common reason is that you argue that the specimens of use are produced solely for purposes of filing the application, or that they don't show use of the mark in the ordinary course of trade. And the last common reason for an LOP is a false connection is created by the applicant's use of their mark with either the protester or perhaps a third person. And that brings up a point I wanted to raise. We get a lot of questions for the likelihood of confusion objection, and protesters want to know if they have to own the registration that they are asserting should serve as a bar to the registration of the mark in the application. And the answer is no. The protester does not need to own the registration. The protester, as with the false connection, does not need to be the famous person. We have seen those. It's the issue if it's a letter of protest filed before publication. The issue in terms of evidence is the evidence relevant, and should that be sent to the examining attorney for them to consider? So we don't necessarily require the protester to be the owner of the marks that they are using as a basis for their letter of protest. Although I must say, oftentimes, most of the time now, after TMA's enactment, the protester is the owner of the registration, but that is not a requirement. So some inappropriate reasons for filing a letter of protest. Some protesters will file their letter and claim that they have some sort of prior rights or prior use of the trademark from the applicant, as opposed to the applicant. That is not a basis for a letter of protest. The examiner does not have the authority or the resources to research a common law prior use. Other inappropriate claims would be that the protester is asserting that the applicant is not the true owner of the trademark in the protested application. That also is not something that is within the examiner's ability to research. So that is not an appropriate reason for filing. Another common inappropriate reason for filing is that the protester simply disagrees with the examining attorney's examination of the protested application. That is not something that is a proper subject of a letter of protest. So that takes care of the following discussion topics. Again, if you guys have questions, please refer to tmwebinar@uspto.gov. All right, so evidence. There have been a lot of changes with evidence requirements in the letter of protest, and we have tried to give potential protesters some guidance on what we can accept and what we cannot accept, and what they minimum standards of things that they must provide. So the first thing that is new under the 37 CFR 2.149 codification of letters of protest procedures is that if evidence is required for your objection in your letter of protest, you must include an index itemizing that evidence. If you want to see an example of what the index could look like, I'm going to show you that on the next slide, but it is located on our practice tip page on our website. An important thing to note about the index is that it cannot contain any arguments or persuasive language related to your letter of protest, nor can it identify the protester in any way. If it does, if the index has arguments on it, persuasive language on it, or identifies the protester or perhaps the protester's law firm, the letter of protest will not be considered. So a common example that we see with this is that a protester will prepare their index on their letterhead with the name of the business on the letterhead itself, their address, their phone number, everything. So that index cannot be used, and it will result in the letter of protest not being considered whatsoever. So here's the example that we have on the tip page about the index of evidence. You'll lay out each exhibit that you have. You'll tell us what kind of evidence it is, the ground that it supports, and you would simply say, so for a likelihood of confusion objection in your letter of protest, you would just say that the ground support is a likelihood of confusion. You would not go on to present a sentence or a paragraph there to show why this evidence supports a likelihood of confusion. You just would say likelihood of confusion, and then you tell us the page number of where the exhibit appears, or page numbers of where the exhibit would appear, and then you move on to the next. This is not a required index format. It's just a sample, and we've seen people that have begun to use this and use it successfully in creating their indexes for their evidence. So with a letter of protest, how much evidence should you submit? And the answer is that you can submit up to 75 pages of total evidence and 10 items of evidence for each specified reason in your letter of protest. So it's 10 items, up to 10 items of evidence for each specified reason in your letter of protest, but no more than 75 pages total. Now, sometimes you might need to submit more than 75 pages of evidence. Well, what are you supposed to do? So in your letter of protest, if you are filing more than 75 pages of evidence, you should include, or you must include, a detailed explanation about why you need to have more than 75 pages of evidence. Otherwise, your letter of protest will not be considered. 37 CFR 2.149 specifically requires that you provide this explanation, and if you do not, your evidence is not in compliance, and the letter of protest cannot be considered. So, real quick, I get the question on occasion about what would be a good explanation. So, in your letter of protest, let's say that you have several grounds for objection, and the evidence is different for each of those grounds. Well, that might take you above 75 pages. That's a legitimate reason. So you would state that. we would most likely accept that and then review your evidence and submit what we can, if not all of it, to the application record for the examining attorney to consider. So next, I'm going to talk about the specific common reasons for letters of protest and the evidence requirements for each. So first up, most common, likelihood of confusion. We need you as a protester to provide the registration number or the prior pending application serial numbers that support your likelihood of confusion argument, your objection in your letter of protest. If you have more than 5 registrations or prior pending applications that you are raising, you should know that we will only consider the first 5 listed. We won't pick and choose. If you have more than 5, we go with the first 5 that are listed. So to that end, you should only submit the 5 most relevant registrations or prior pending application serial numbers that contain the mark that you are saying should serve as a bar to registration under Section 2D. Now, note that I said that you must provide the registration number or prior pending application serial number, and really, that is all we need for purposes of identifying the registration or the prior pending application that you want to be placed in the record for the examining attorney to consider. You do not need to provide the entire copy of the T's or TSDR records for each registration. If you do, you may find that you get above the 75 pages real quick. So, in an effort to help protesters not have to provide evidence that we already have in our records, you only need to provide the registration number or the prior pending application serial numbers that support your likelihood of confusion objection. So, if the goods or services identified in your application, in the application on record and the prior pending application or the registration that serve as a basis for your objection, if the goods and services identified therein are not identical, you are going to need to submit evidence showing that the goods and or services of the applicant are related to the goods and or services identified in the registration or the prior pending application that you are using as a basis for your likelihood of confusion objection. So that would be anywhere from 1 to 10 items of evidence supporting the likelihood of confusion grounds, showing that the goods and or services in the application are related to the goods and or services identified in the registration or the prior pending application. You can use records from TESS or TSDR on our website. Those records will show the current status of the registration and prior pending application. It'll show the owner, and you can use it to show the goods and services as well. Another method to show relatedness would be third-party websites showing the goods, the 2 types of goods offered by the same online retail store under the same mark. That would tend to show that those particular goods at issue are related. But an important point, and you'll hear me say this several times, about websites that you would provide, you must include the URL and the access or print date of each web page that you're submitting as evidence. Otherwise, we can't authenticate it, and it is not something that we could use. So please don't forget that. That's pretty standard practice now for many of the letters of protest that I see, but it is something that we feel is important to mention and mention every time we talk about website evidence that would be used by a protester from a third party. So for printed publications, you need to identify the name of the publication and the date of each publication. So if you have several publications, we'll have several dates for each. For the next common reason for descriptiveness or genericness, the best evidence that we see is from an online dictionary, it could be an online dictionary that is specific to a particular trade, or it could be Merriam-Webster. But we would need that evidence, again, to show the URL and the access or the print date if it's an online dictionary that you're submitting. That's the best evidence. Sometimes that's not available. So third-party websites showing the applied for mark that you're protesting used in a descriptive or generic manner for the same goods or services that are in the application that you're protesting, that would serve well. Again, we would need the URL and the access print date of the website evidence. You could also use evidence of descriptiveness or genericness in use-based registrations here at the PTO. With that, you would include copies of registrations from either TESS or the TSDR database showing the current status and owner of that registration or each registration that you submit. And again, just like with 2Ds, you could use material from printed publications as long as you provide the publication name and date. So third, when a registration is used by an applicant in their identification of goods, and you're the owner of that registration, or you see it and want to protest it, all that we need you to provide is the registration number. If you want, you're not required to do this, but it is helpful. If you would like to provide us with the language that you think that the applicant should have used to describe their goods, you can tell us that, and we will forward that to the examining attorney to let them know, and they can decide on that. But again, here, we just need to know the registration number, and we will forward that on to the examining attorney. We do not need you to submit any evidence other than the registration number, which you will do in the form. I'll show you how to do that in a minute. All right, so. Next common reason, a widely used or commonplace message. So the protester asserts that the wording that's used in the applied for mark is a widely used or a commonplace message, and they do not think that the particular application should be registered and it should be refused registration. There's a lot of evidence that one can use to support this refusal, but I want to make it clear that the most important piece of evidence that you must submit is evidence showing what the public perception of the meaning of the widely used message or commonplace phrase is. So, just as an aside, an example would be, have a nice day. That has a particular meaning and evokes a certain feeling. It's been around for a long time. You could go onto the internet in the information age and find evidence that shows what that particular phrase means in the eyes of the public. That's the kind of evidence that you must submit if you are objecting to a particular mark in an application and you're asserting that it's a widely used or it's a commonplace message. So if it's widely used and it's a commonplace message, it has a meaning that's known by the public, such that the public wouldn't look at that phrase as a trademark. They would look at it as a widely used or commonplace message that evokes some sort of meaning or feeling, and that's not a trademark. But if you're objecting or filing a letter of protest on this ground, you need to provide the evidence of what that means. The next type of evidence you would provide would be evidence showing other people using it. And by other people, I mean not the protester and not the applicant. How are other people using this widely used message in everyday speech? You'd find it in news articles or on web pages or in blogs. You would submit that evidence. You also could submit evidence from online retail stores showing products with the particular phrase or message on a shirt, on a hat, on a cup, on a scarf. But if you don't show what the phrase or the widely used or commonplace message actually means, then your letter of protest will not be considered. Again, all website evidence that you would submit, you'll need to have the URL and the access or print date for each of the websites that you use. Print and publications, we would need the name and the date of the publication. Another common reason for a letter of protest. Now, I say common reason, it's a relatively new one that we are starting to see more of, and that is that the specimen is not in use. What sort of evidence would you provide to show that the specimen that the applicant submitted with their application is not real or not one that is actually in use? Evidence that you would submit would be third-party websites showing an image of the goods that the applicant shows in their specimen, but maybe without the particular applied for mark on that image from the third-party website. Again, you're going to provide us with the URL and the access to the print date of each website that you use. You could also submit a forensic report. There's forensic software that's out there that you can use to show that a particular image was doctored or altered or mocked up. We would use that evidence and submit that to the record for the examining attorney to consider. You could also provide us, if you are aware of a particular bad actor, you could submit the application serial numbers, or perhaps registration numbers if they got through, for different marks that use the exact same image with a different trademark on it in each of the applications. You could submit those registration or serial numbers. That would be helpful in supporting your objection. Another method is to show that the UPC barcodes that a applicant may have on several of their specimens, you could show that the UPC barcodes are identical. You could find a way to prove that the specimen that they submitted was not in use or even existed prior to the filing date of the application, assuming it's based on use. You could also provide images from online retail websites showing that the identified goods in the protested application are not available, but you'd have to combine that with some other evidence of non-use. Again, though, let's go back to the rule about website evidence. It must include the URL, and you must include the access or print date for each website in order for us to consider it. But before we move on to the next type of evidence, I want to show you an example from a letter of protest that was arguing that the specimen was not in use and how it looked, how did the evidence look that the protester submitted. So in this particular case, the goods were headphones or earphones. The specimen shown on the right belongs to the applicant. The protester provided the web page image on the right. So on the left is the applicant, and if you look at the box that is holding the headphones, you'll see the trademark is written on the bottom of the box there. If you look at the same image over here on the right that was used in the evidence that the protester submitted, they used the same image, but that particular image doesn't have a trademark on it. Now, in this case, the protester did submit other evidence, other third parties using this exact same image. So at the very least, it calls into question the applicant's specimen, and the examining attorney should question that if this evidence could be placed in the record for the examining attorney to review and act upon. So this, I see this kind of letter of protest with this type of specimen a lot. This is the easiest way to show that the specimen that the applicant has submitted may not be legitimate. So I show you this just to show you that it can be done, and this is the type of evidence that supports the particular objection that the specimen is not in use. All right, so moving on. The last common letter of protest objection is that the protester is asserting that the applied for mark has a false, creates a false connection with the protester or some other party. So the evidence that we look for here is third-party websites or magazine articles, newspaper articles that refer to the protester or the party that the protester is raising, showing that the proposed applied for mark would be viewed as pointing uniquely or and unmistakably to the protester or the other party. So it could be any type of website evidence that you might find, but again, we need a URL and the access or print date for the website. And with printed publications, we need the name of the publication and the the date of the publication. Before we move on to the next section, I get questions sometimes about how do you keep your evidence under 75 pages? And one method that we suggest is that you do not submit a copy of the prosecution history for the protested application or the registrations that you're submitted as third-party registration evidence. We do not need all of the prosecution history. We already have that. We just need you to provide the registration showing its current status, that if you're relying on it, it should be a live registration. It should be based on use. So use your 75-page limit very conservatively and only submit what you need to submit. So in terms of the documents that you're submitting that are already in our office records, don't submit things that we would have available on our systems as well. Also, don't provide any information or evidence about an alleged prior use that you may have, evidence of actual confusion or any declarations that you may have. Those are not appropriate subject matters for evidence in a letter of protest. Now, they are appropriate, though, for an inter-parties proceeding at the TTAB. Lastly, don't submit evidence that the examining attorney used in their office action in the protested application. Again, that evidence is already of record. If there are any questions on this evidence discussion topic, and I'm sure that there will be, please go back to tmwebinar@uspto.gov. All right, so the next discussion topic, the letter of protest form, the form itself. What does it look like? How do you find it? What do you do? The letter of protest form is found on our website in the petition forms. It's a TEAS form. If you filed an application before, filed anything here at the PTO, you'll recognize the TEAS forms. This is one of them. It's number 10 in the petition form section, and it looks like this. You'll have entered the serial number, and when you hit enter, you'll have a box come up asking you to check the box for your the basis for your objection in your letter of protest. So you could check the likelihood of confusion and enter the registration numbers or the application serial numbers in the text box there. You can check that the mark is generic. or that it's merely descriptive, or check all three if that's something that you're going to be asserting in your letter of protest. Notice the last box, other legal basis, explanation of legal basis. That is a free-form text box, so you can write a basis for your objection there if it's not one that's in the check boxes, and if it's one that we can consider, we will. But moving on. The second page of our form is where you would attach your evidence. Now, there's a lot of instructions here in the evidence. This form was last updated over the summer. It most likely will be updated before January 31st. Our hope is before January 31st. So some of the things that are listed here will change. You will notice in our letter of protest form, it still says that you need to provide, if your objection is based on a likelihood of confusion, that you need to provide an electronic copy of the U.S. registration or the prior pending application that forms the basis for your objection under Section 2D, likelihood of confusion. That is no longer the case. The form has not been updated, and so we'll take that evidence if you want to submit it, but you do not need to submit that evidence, especially in light of the fact that you're limited to 75 pages and 10 items of evidence per objection. So those pages that you would submit would be considered part of the 10 items of evidence and in your total 75 pages. So I recognize that what I have said is different than, is different than what the form is saying. So I just want to alert you to that the requirement is that you submit the registration number and or the prior pending application number, and nothing else for your identifying the registration or prior pending application that forms the basis of your letter of protest objection under Section 2D. So moving on to the next page here. As we said at the beginning, you have to provide your name, you have to provide your email address, all this other information. The required data fields are marked by a red asterisk. Then, of course, you'll sign the letter of protest with the e-signature, and you will validate it and then pay the fee and file it. So that is the form. It's pretty simple. We hope to make it simpler for you, but this is how it stands right now. So you've submitted your letter of protest. You've had your evidence in there. You had an index. You had, let's say, 7 items of evidence that support your objection, and it is reviewed by a petitions attorney here in the petitions office, and your letter of protest is considered. So what happens then? Your letter of protest is considered. What does it look like when it's considered? You'll get a letter, and it will say that your letter of protest identified an objection, and we have considered it, and we are forwarding it on to the examining attorney, and the examining attorney will make a determination about whether or not to act on that evidence. So this is what your letter will look like. Now, this letter itself will not be in the record, but what will be in the record? So you'll see in TSVR, in the prosecution history, you'll see this entry for letter of protest evidence forwarded. So that's how you know that your letter of protest has been considered and the evidence has been forwarded to the examining attorney. But the letter itself will not be in the record because it identifies the protester. But the evidence is forwarded to the examining attorney. So this is what it looks like in the prosecution history. And as far as for what the document would look like in TSDR, you'll see in the document listing an administrative response. It's from the same date. I'm going to switch back here. May 11th, letter of protest evidence has been forwarded. And then if you go and you look in the documents, you can see what actually was forwarded. So in this particular letter of protest, there was a lot of evidence that the protester submitted. But Not all of it was usable. So the usable evidence was forwarded to the examining attorney. It's referenced here in the letter of protest memorandum, which we call an administrative response in the document listing. And this evidence on the right from Executive Gov, that was attached to the memorandum. Also note, in this particular letter of protest, there were two bases for the letter of protest objections. One was that there was a likelihood of confusion. The registration number is listed as the first reason for the letter of protest, and the second was a false association. That was evidence for the examiner to consider. Now, this evidence may not be enough for the false association argument, but it's something that the examiner can use and build upon to make that refusal if they determine that they should. So sometimes a letter of protest is not considered. And I'd like to go over the most common reasons about why we would not consider a letter of protest. The most common one is that the protester raises an objection and they don't provide any evidence whatsoever, or they provide evidence that we cannot use. Maybe they didn't have a URL. Maybe the evidence was, the screen capture was off and they still submitted it. So if we determine that the letter of protest has no evidence and evidence is required for the objection, then we will not, excuse me, we will not consider the letter of protest. Another one that we're seeing a lot of is that the letter of protest has evidence and it is required to have evidence, but the protester doesn't provide an index for that evidence. Evidence is required under 37 CFR 2.149. They are required to provide this evidence, and if they do not, if a protester does not, we will not consider the letter of protest. Another common reason is that there is information written on the itemized index or even the evidence itself. There's arguments written on that information that identifies the protester, or it identifies the protester. An early example I gave is that for the index would be that the protester uses their own letterhead and identifies themselves on their index because it's not a blank white sheet of paper. It has who they are on the top and then the index. We can't use that. We are identifying the protester there. It may also be that the protester presents arguments on the evidence itself, their reason about why their evidence supports their particular claim. We cannot use that evidence either, and if that is all that we have, then we go back to number one up there, where we have to consider that that letter of protest has no evidence, and evidence is required for the particular objection. Therefore, we cannot consider the letter of protest. The next reason is that a protester will submit more than 10 items of evidence to support their objection, or they'll submit more than 75 pages without an explanation of why they need to submit more than 75 pages. If that occurs, we will not consider the letter of protest. Particular to a letter of protest based on a likelihood of confusion, and the protester is submitting evidence trying to show that the goods at issue are related, and they only rely on foreign registrations, or they rely on 66 or registrations based solely on 44. So those applications were registered, but they were not based on use, and the registrations, at least unless they follow Section 8 information down the road, if they're not based on use, then they cannot be used to show that the goods and or services are related. And if that's all that they submit, then we don't have evidence that we can use to support the objection to forward to the examiner, so that letter of protest cannot be considered. Another one that we see at times is the protester will have a typographical error when they identify the registration upon which the letter of protest is based. this could be not just for 2Ds, but this could also be for registrations that are used in a particular identification of goods in a protested application. So if you give us the wrong serial number or registration number, that registration is not going to be the mark that you want to use to support your objection, and we will not try to figure out what you meant. If there's a typographical error in the registration number that you provide, the letter of protest will likely not be considered. Another one, going back to website evidence, if the protester's evidence does not have the URL or the access date of the web page that you're using as your evidence, if you do not provide that, then that evidence will not be used. And if that's all that you have, then you have no evidence and the letter of protest will not be considered. The same goes for the publications. If you don't provide, for printed publications, if you don't provide the name and the date of the publication, then it's not evidence that we can use. If no other evidence is included, then again, the letter of protest cannot be considered. One other thing that I see, and I understand why people do this, but they might give me 2 screen captures on one page that they submit as evidence, and that is certainly permissible. But if one of those screen captures on that single page are not compliant, let's say you have a URL for one bit of evidence on that page, but you don't have a URL for the other, maybe it was cut off in the cropping or something like that, then that entire page of evidence is not going to be used. And if that is all that you've submitted, there is no evidence to support your objection. Your letter of protest cannot be considered as a result. And then the final common reason for us not to consider a particular LOP is that you raised a particular objection and the examining attorney has already issued an office action on raising that particular objection, that same objection. Now, it may be that you submit evidence that the examining attorney did not use, and it's good evidence. In that sense, we will take the evidence and present it to the examining attorney in the record for them to use should the examining attorney have to issue a final office action on that particular objection. But most likely, your letter of protest would not be considered because the examining attorney will most likely use the same evidence that you would use. But if not, and if the evidence is relevant, we will send it on to the examining attorney in most instances. So your letter of protest, unfortunately, let's say it was not considered. What does that look like? Well, we send you a determination letter, and it is a form letter, but it looks like this. After the section that says the LOP will not be considered because it does not meet the legal requirements specifically, and we have a box that we will check and tell you why, we do provide a little bit of information about why we were not considering the letter of protest. In this particular one, the letter of protest was asserting a likelihood of confusion in a registration that the protester owned. And the goods in the protested application and in the registration that the protester owned were not identical. And the protester did not provide evidence that the goods were related. So the letter of protest was not considered, and we let them know that the reason it was not considered is because they did not provide evidence of relatedness. So as I said before, if your letter of protest is not considered, it will not be in the record. There will be no information in the record about the letter of protest. So this is all that you will see about your letter of protest if it is not considered. So one thing that does come up, your letter of protest has been considered. It has been put into the record. You can see in the prosecution history that the evidence was forwarded, but the examiner decides not to act on it. It's a pre-publication letter of protest. It is within the examining attorney's discretion to use that evidence to issue a new office action or to not. If the examining attorney reviews the evidence and decides not to take action on that evidence, they will enter a transaction in the prosecution history, and it looks like this. So on November 3rd, you can see in TSDR in the prosecution history, the letter of protest evidence was forwarded. The next day, the examiner reviewed it and determined not to take action on the letter of protest. They entered the transaction here, and you can see it, and that would be the end of that particular letter of protest. The evidence is still in the record, and it will remain there, but the letter of protest evidence, although it has been reviewed, the examining attorney has decided not to act on that evidence, and they will not reference it in anything else that they write. Again, at this point, we're getting ready to go on to the next discussion topic. If there are any questions, go ahead and email them to tmwebinar@uspto.gov, and we'll get to them in a little bit. So, timeliness considerations. We don't see this right now, given the filing surge, but there have been times when a 44D application or 66 Madrid application was not in the office records when the protested application was assigned to the examining attorney, and they did their research on it and ultimately approved it for publication. When that scenario happens, it may be that your letter of protest could be considered late, and you would be asserting that you have a 44D application with a priority date that is prior to the filing date of the application that was published, and you want to file a letter of protest asserting that the examining attorney should have cited the prior pending applications based on Section 44D. So you would file a letter of protest. A petition is not required to do that, although I should note it may be that you need to file the petition to get the letter of protest in the door. After the opposition period ends, the letter of protest form on our website will not permit you to file a late letter of protest. So, or to file a letter of protest after the opposition period has ended. So in order to get it in the door, you may need to file a petition and attach the letter of protest. But a petition itself is not required for that type of letter of protest because it's an office system that caused the problem for you. So we most likely would refund the petition fee. Another timeliness thing to remember is that if we're dealing with a 66A application, you need to have your letter of protest filed within the 18-month deadline after the IB, the International Bureau, transmitted the application to the USPTO. If you do not do that, your letter of protest will be considered untimely and it will not be considered. Another timeliness issue, and we see this a lot with applications for marks that are going to be registered on the supplemental register. If the letter of protest is filed within the opposition period, so 30 days after the application has been published, but the protested application can't be withdrawn from the issuance of the registration, then excuse me, then the letter of protest will be considered untimely. Typically, that happens with, or can happen with a mark that is seeking registration on the supplemental register. Any other situations where you would want the office to waive the timeliness requirement related to an LOP, you would need to do that on a petition to the director. And those will only be granted in extraordinary situations. An example is that an application has been published. It was filed under Section 1B. The application has been published, and the applicant in that case a notice of allowance is issued, and the applicant in that case has filed their statement of use with specimens, and the protester wants to object to these specimens filed at the SOU stage, asserting that the specimens are not in use. Going back to the headphone example that we had, where they can show that the specimen that was submitted with the statement of use in this application might not be legitimate. This is an application that the opposition period has already ended. So the procedures are not set up to accept a letter of protest without a petition requesting that the timeliness provisions be waived. So that is an example of one. Another example would be where the particular letter of protest evidence that you are relying upon did not exist prior to the publication of the application. So any questions on that? Again, tmwebinar@uspto.gov for questions, and we'll be getting the questions shortly. So the additional information section, we're at the end here. If you file a letter of protest, please go review the information on our website. It's an LOP practice tip. You can find that. I go to it all the time to just look and see what we're telling protesters to file when I'm curious about why they did what they did. But it's a practice tip that is reviewed and edited frequently and updated frequently. So if you have filed a letter of protest and it's been a month since you, or you're getting ready to file a letter of protest and it's been a month or two since you filed your last letter of protest, please go and re-review the letter of protest practice tip. If you have never filed a letter of protest and you are thinking about filing a letter of protest, before you do so, again, please review the information that we provide on the practice tip. One thing to know about filing your letter of protest: if you are thinking about filing an opposition or a request for an extension of time to file an opposition with the TTAB about a particular trademark that has been published, filing your letter of protest will not stay any time for you to file your opposition at the TTAB. So consider this two tracks. You have your letter of protest track that you would be pursuing, and you'd have to file your opposition at the TTAB. If your letter of protest is not considered, and you have, and most likely the determination about your letter of protest after publication, filed after publication, you will not receive an answer about that letter of protest before the opposition period ends. If you have not filed your opposition with the TTAB, your time to file your opposition period, your opposition will have lapsed and ended 30 days after publication. So just because you file your letter of protest, don't ignore your requirements to file your opposition if that is an avenue you want to preserve. So if you need to contact the petitions office about a letter of protest that you have filed, our phone number is 571-272-8950. We're open. There's someone there typically to answer the phone from 8:30 to 5. If you have to leave a message, they will get back with you within 24 hours. If your message that you leave or the reason that you're calling requires the assistance of a petitions attorney, you will be referred to one. There are, I believe, 20 of us, maybe 18 of us, but one of us will definitely be able to help you. So, moving on to questions and answers. I'm sure some questions came in. Craig, are you available?
Yes, I am, John, and we have a lot of questions, so let's just see how many we can get through.
Great.
The first, the USPTO did not consider my LOP, but the protested application is still pending. Are there any remedies, and can I appeal?
Okay, so I'll answer the first part, the last part first. There is no appeal procedure for a letter of protest that has not been considered. However, the protester can always file a second letter of protest as long as the opposition period has not ended. So if an application has just been filed and you file your letter of protest, and let's say in your evidence that you did not provide, you provided internet evidence or web page evidence, but you didn't provide the URL or the date for that evidence, your letter of protest is not going to be considered. You could then turn around and file a new letter of protest with the same evidence, with the URL and the date that the information was accessed, and have a better chance of your letter of protest being considered. So your remedy here is not to appeal somewhere in the PTO. Your remedy is to file a new letter of protest, and we see that a lot.
Okay. I filed an LOP objecting to a mark that I think is a widely used or commonplace message. I attached evidence from Etsy, Amazon, eBay, showing lots of merchants selling T-shirts, mugs, and hats with the applied for mark on the goods. Why was my LOP not considered?
Well, I don't have the particular LOP in front of me, but I can tell you most likely why it was not considered based on your question. If you only provided evidence of the mark used on goods by online retail stores or folks from Etsy, Redbubble, or the other places that you listed, if you only provided that evidence, well, that evidence doesn't show how the particular mark, this phrase, would be perceived by the public. All that evidence shows is that a lot of people sell it with the mark on the goods. In order to support your objection, the refusal for a widely used expression requires that the examiner show what the phrase or expression actually means. And if it has a meaning, we live in the information age, and you can find it on any dictionary or third-party website might be able to show you. But I have considered these types of LOPs when a protester has provided the meaning of the phrase by using Urban Dictionary. Part of the beauty of trademark law is that you're unlimited in the evidence that you can use. So that is one place that people are turning to provide evidence as to the public's perception of what a particular word or slogan or widely used expression or commonplace phrase would mean. But that's just one reason why it might have been objected. Again, if you didn't provide the URL for those, URL and the date of access for that bit of evidence, then that evidence would not be considered. So that's two big reasons right there. Well, I do commonly get asked about letters of protest, some letters of protest statistics that we have. People want to know how many letters of protest do we get a year? And I have last year's data. We had over 3,500 letters of protest filed. For the fiscal year, 3,200 of those were assigned. And of those 3,200, those are for pre-publication letters of protest, 3,200 of those were assigned to petitions attorneys here in the office, and 76% of them were considered. So that's a lot that were sent to the application records and to the examining attorney to take action on. 43% of those were actually acted on by the examining attorney. For post-publication letters of protest, last year we had 410 of those were assigned to petitions attorneys. However, keep in mind, a post-publication letter of protest has a higher standard of a higher bar in terms of what they must prove. They have to prove a prima facie case for the refusal or the requirement, such that the office failure to issue that refusal or make that requirement would be a violation of the Trademark Act. We have 410 of those that were filed post-publication last year. Only 23 were accepted. That's 5.6%. Post-publication letters of protest were not. 5.6% were accepted. I have a couple questions coming in electronically, and one would be about the URL and the date for the website evidence. And the question is, like, where should that be? Should it be, on the LOP letter of protest form, or should it be should it be on the evidence itself? It really should be on the evidence itself, because, as I said, the letter of protest itself, the form, is not forwarded to the record whatsoever. So if you put the URL and the date on the form, as opposed to on the evidence itself, we have no way of getting the URL and the date associated with the particular piece of evidence that would be submitted to the record and forwarded to the examining attorney. So typically when folks do a screen capture, they can capture the website address at the top of the page, or they have capturing software that will automatically list the date and the web page at the bottom of the screen capture. That is ideal evidence, ideal website evidence for you to use. Craig, are you back? Was he able to get back?
He is on, but he just needs to unmute. There he goes.
Yes, so here we go. Sorry about that technical problem. This question, John, is fairly straightforward. Are LOPs discoverable under the Freedom of Information Act? I'm sorry, I don't have an answer to that. I don't handle any of the FOIA requests at all, but I can find out, and I will. We probably will send out a frequently asked questions document, and I'll have the answer in there. I would assume that much of the information about the protester would be redacted, but I think I'm speaking out of turn because I do not have an answer for that question. I apologize. Right. When I said it was straightforward, John, it was going to be a yes or no answer, but unfortunately we don't actually have the answer there, so that's certainly quite all right.
But I have a coworker who is watching who said, yes, they are. So they are. Thank you. Yes, they are discoverable, or we will provide it if you provide the Freedom of Information request.
Okay. Is it possible to fix an LOP in any way, or will this automatically cost an extra $50?
When you file your letter of protest, we do not accept amendments to your letter of protest. So you are correct in that you would file another letter of protest, which we would, if the error in the letter of protest is one that renders it such that we can't consider it, we'll send you a document saying we have not considered your LOP, and we'll tell you why. And again, we also say you can file another letter of protest, but that would be your remedy there, is you would file a new letter of protest.
Okay. Someone here, John, is referencing when you were displaying the form and indicated that the widespread use was not displayed as a checkbox in that form. Where do you indicate that, if that's your basis?
All right, let's go back to that form, if that's okay with folks. So in the I'm scrolling too quickly. In the form itself, You'll see other legal basis, explanation of legal basis. You'll see a text box at the very bottom there. That is where you would write it in. Okay?
So the next question, John, relates to claiming the likelihood of confusion basis, and it asks, is it necessary to include an index when the only evidence would be the existing certificate of registration?
Well, no, we would not need an index, and we would not need the certificate of registration. We only need the registration number upon which you are basing your objection in your letter of protest. So we don't need evidence of the registration that you think the examiner should cite. We just need the registration number.
The next seems to be somewhat related. Which grounds for the LLP do not require evidence?
Well, we'll start with the 2D. If the goods in the registration that the protester is relying on and the goods identified in the application are identical, then you do not need to provide evidence that the goods are related. If the goods are identical, that is enough. That doesn't happen all the time, but it's enough for us to see it, for me to mention it. It happens enough. So that's one instance. Another instance would be the registration that you are relying on in your letter of protest is the mark in the registration is being used by the applicant in the protested application in their identification of goods. The owner of the onesies trademark often files letters of protest when they see an applicant identify clothing as a onesie. Well, onesie is a registered trademark. It is not a type of clothing. It's a trademark for clothing. So they only need to provide the registration number. Another example would be if you're relying upon a federal statute that protects a particular emblem or symbol, Boy Scouts of America, Red Cross. Those are three off the top of my head. But most of the time, evidence is going to be required. Some evidence is going to be required. And if evidence is required, then an index is required. That's what I want people to really just remember is that if I'm providing evidence and evidence is required, then I need to give an index for that evidence.
Okay. If an opposition period is extended, does the original 30-day period still apply with regards to the LOP deadline?
Yes.
If the protester is not the owner of a mark being raised in protest against a pending application, does the owner of that mark discussed in the protest get notified that its mark is in fact involved in a protest?
Craig, could you read that one again for me, please?
Right. So if the protester is not the owner of the mark being raised in the protest against a pending application,
okay.
Does the owner of that mark discussed in the protest get notified that its mark is in fact involved in a protest? No.
We do not reach out to registrants. Certainly the protester can, but we don't require that the protester be the owner of the registration, but at the same time, we're not going to go and contact the registrant and say, there's somebody acting on your behalf. So, no, we do not.
This question relates to a situation where the LOP is considered, but only some of the evidence is forwarded to the examining attorney. What are types of evidence that, in fact, would not be forwarded?
Well, for pre-publication letter protest, if we don't deem the evidence to be relevant to the particular objection, then it will not be forwarded. But other evidence in a letter of protest might be relevant, so it would be forwarded. A lot of times what I see is in some of the examples that I gave for a letter of protest for common reasons for not being considered, perhaps the letter of protest has 5 items from 5 different websites, but only 2 of the websites actually list the URL and the date, or maybe they list the URL but don't list the date, or they list the date but they don't list the URL. So we go through each piece of evidence and determine what can be forwarded and what cannot be forwarded. And we always try to forward the evidence of what we can forward, we will. But sometimes all of the evidence that you submit as a protester is not forwarded to the record. It could be also that perhaps it was mutilated or incomplete, and that the picture that you submitted is not a complete picture of the website such that it's illegible. We won't forward that either. I can't think of any other reasons, but other than to say that we go through the evidence, and if it relates to the refusal, if it's relevant to the refusal, we will forward it if it complies with all of the other requirements for evidence or for the letter of protest.
Okay. John, can an attorney's email address be provided for the protester's email address to avoid spamming and preserve the protester's confidentiality of email address?
Well, the letter of protest itself is not made a part of the public record. We will send the letter of protest to the correspondent email address that's listed in the letter of protest form. Let's go to page 32. We are requiring an email address in our letter of protest form as a place to send the decision or determination letter to. We do have to have that, but we're not requiring too much information about the protester themselves. So we just need an email address of where to send the determination letter about the letter of protest. So if you look at what I have here now on slide 32, if you look at our form, we're asking for an email address, but not an email address of the protester. We do want the protester's name, that is true, but this is not put into the record.
Okay. You may have covered this, John, but if you could go back through as to what actually does or does not issue when the LOP evidence is not considered. Is there a specific letter that someone will see when that's the case?
Well, the only person who's going to see it is the protester. If a letter of protest is not considered, none of the information about the letter of protest, none of the evidence that was attached to the letter of protest, none of that is placed into the record. There's no indication in the prosecution history that a letter of protest was ever filed, but the letter of protest, the protester will get a notice from the PTO saying that their letter of protest was not considered, and it will look like slide 39 that I have on the screen right now. That is what they will receive.
The next question, John, when did the new rules go into effect? I submitted an LOP on November 5th, and would not have submitted an index of evidence as I wasn't aware of the new requirement. Should I resubmit another LOP with the index? Can I do so without incurring another filing fee?
The TMA went into effect, I believe it was January 2nd of 2021. We recognized that there was not a lot of notice about the new changes, and so we posted the LOP tips page on the website for the USPTO. The index requirements, we began enforcing the index requirement in August, but it was always a part of the new rule effective January 2nd of 2021. My advice, as far as for the letter of protest that you filed on November 5th, if evidence was required for your objection and you did not provide an index, that particular letter of protest will not be considered because it does not have an index, and index is required for the objection. The remedy is to file a new letter of protest with an index for the evidence, and that would be a new letter of protest, and a new filing fee would be due with that letter of protest.
Okay. The next one, John, is looking to the TME provision about LOPs, and it indicates LOP should include only a simple statement of the proposed legal grounds for refusing registration or issuing a requirement, together with succinct, factual, objective evidence to support the refusal or requirement. It should not include arguments. I think that's where the question is focused. The part about it should not include arguments. Could you clarify that?
Well, yes. I think what they're asking is, on the evidence itself, should it conclude? It should not include arguments, or in their statement. Well, we don't need. Well, if the protester wants to present a further explanation of their objection in their letter of protest, they can do that in the form. Some protesters write it on a piece of paper and attach that to the letter of protest form, but that's not evidence. You know, that's not considered as evidence. So if they want to flesh out their likelihood of confusion argument or flesh out their merely descriptiveness argument, they can do that, but they cannot do that on the evidence itself or on the index for the evidence. I hope that clarifies.
Okay, John, we're going to have the last one as the last question because we're hitting our time, and there have been really a lot of good questions submitted that we could not get to, and we'll have to figure out whether we will separately be able to follow up. I don't want to make a commitment as to that right now, but let's wrap up, John, with this question. Can we manually type the access date onto a page where we insert a screenshot, or must the access date actually appear on the screenshot when we do take that screenshot?
Excellent question. I'm so glad you asked that. You can manually put it on there. As long as we can verify it, it's fine. So if you need to type it in onto the screenshot, if that's what your computer and the software that you have will if that's as far as it can go in terms of capturing the URL and or the date, then that will be sufficient. If you provide it, what I'd like to do though is to clarify that should be on the evidence, not in the LOP form. It should be on that page of evidence, the URL and the date.
Okay. Again, John, we received a lot of good questions. Some of them, quite honestly, had 5 or 6 parts to them, which were very difficult to try to ask out loud, but we'll see if we can have a follow-up. But otherwise, I think we will need to wrap up. And again, apologies that there was a little technical glitch where I was dropped from the call, but I'm glad we could get back in.
Me too.